Do you think life is simpler as time evolves? For some, it can be more complicated when facing issues about health, estate plans, probate, long-term care, and more. That's why Attorney-CPA Joe Cordell hosts ElderTalk with TuckerAllen, providing intelligent answers for those thinking about their future. Here's Attorney-CPA Joe Cordell.
Welcome to another episode of ElderTalk. We're talking about the process of assuring that you can have your long-term care paid for in a way that does not require you to exhaust your savings. So this is a second of a two-part series in which we want to introduce and explain the basics, more or less, of Medicaid qualification. And many people have heard reference to this, and some have a little bit of familiarity. Many of you don't. Many of you close your mind immediately when you hear the word Medicaid, because I'll assume that most of our audience, just like many of the clients of TuckerAllen, tend to be middle class, meaning they're the people who have always worked, and they've had very few benefits that they've qualified for or that they've even sought in terms of governmental benefits, state or federal. And they feel a bit of apprehension or reluctance or even guilt about the idea of applying for something like Medicaid.
Or they just don't think they can qualify.
Yeah, in some case, you're right. And part of it thinks that that wouldn't apply to me. Yeah, right. And that's a good part of people. So we wanted to explain to you that, no, in fact, the way the rules are written, you can actually take steps so that you can qualify for coverage, and that's what we're going to be covering here more. And we want you to be aware of this, because many people needlessly surrender everything that they saved and worked for their entire lives. I mean, you may not have a big nest egg, but you may have $500,000, which I'm always reluctant to say numbers, because you have people out there saying, wow, that's a big number. And then you have other people saying, that's not anything. So it's all a sense of reference or point of reference. So whether it's $500,000, whether it's $200,000, whether it's $1 million, probably not $3 million. I mean, there's a point where we would not suggest you do this. Not that it's impossible, but people generally don't have an interest when they have certain levels of savings. It's really those people that have this amount that wouldn't be considered by many a huge amount of money, and it's all they have to give to their loved ones. And you've worked hard. You have grandchildren. You have children. Maybe there are others, maybe charitable organizations that your church, that you may want to provide these assets to, and you're really counting on being able to make a difference in the lives of or those organizations. And why lose that ability when you don't have to? And we've talked about the fact the laws are written in a way that you really, for most of you don't have to. You can still qualify for this long-term care coverage, which can easily run $10,000 a month and will run $15,000 a month. I can tell you, we're looking at those numbers, and I don't even have to tell you that. You're seeing the news. Inflation rate, depending on who you believe, maybe as high as 10, even 11 or 12%. What's quoted was actually closer to 5%, but that's based on the overall basket of goods, a CPI basket. Depending on which goods you want to emphasize, your inflation rate could very well be closer to 10%. So it's not difficult to imagine a scenario in which you're going to have long-term care costs, which tend to lead the pack in terms of increases in prices, that could very well be $15,000 plus a month. So that's the purpose of this show. With us today, we have somebody who is eminently qualified to discuss this, Jim Gau, who's one of the attorneys at TuckerAllen. He's been on here before, so he's our go-to person to answer these questions. Jim, welcome back.
Thanks for having me yet again.
So I'm going to assume that our viewer, if you want to get up, let me shift gears. If you want to get up to speed on what we did last time, look at that, revisit that, and we won't spend a lot of time sort of recovering or recapitulating what we dealt with in the last show. Our intention was to talk a little more about assets then, so we're going to shift now and talk a little bit more about what's the income piece, what are those rules, and then we want to give you an idea of what steps you will face if you come in a planning situation or you come in a crisis situation. Planning is, you'll recall from our previous one, is that you have a period of time to plan. It's not an emergency, and we'll revisit those principles a little bit. And then that situation where something's happened and you need to get qualified soon, a loved one or you. So let's go with that, Jim. I'll give you the floor.
So, yeah, I mean, kind of just to do the Google search term recap of the last one, I think the important topics are kind of the look-back period, which is the pre-planning time that we should, optimally have 5 years to pre-plan this, as well as Medicaid Asset Protection Trust. We'll talk a little about the snapshot rule and the name and the check rule, things like that. So if you want to get a little deeper education, obviously watch the first episode of this, but also Google some of those terms as well, and you can get a deeper understanding that we can possibly go into here. Now that being said, I'm an attorney that just basically told you to use Google, but it does help to prepare for meetings at least. But so I guess the first thing that people always ask is, when should we start planning for this? When's the emergency situation coming up? And it really is the earlier the better. I mean, so as with most estate planning and all estate planning, really.
Could this be when someone, say, is in their 40s?
Usually I see retirement age. So once you get to retirement age, you've now got a fixed income. You're no longer, and it's lower than what you were making, in employment. So you get to retirement age, you realize, we've only got this X dollars amount per month in income from our Social Security, pensions, retirement accounts. We know we can't pay for a nursing home using that. Now what? And you're not accumulating assets typically in retirement. So that's normally when I see clients coming in. You do have the people that are pre-planners just by nature.
And remember, too, that whenever you implement these plans, they're probably going to involve using an irrevocable trust. So we told you last time that you want to probably not put everything in that trust, and it does mean living with some rules. You can't use the money as you otherwise would. That's the kind of quid pro quo in exchange for getting protection so that you get to keep the money and still qualify for these benefits. So most people, when they're coming in like their 40s or 50s, they don't want to make those concessions unless they see something, unless there's been a diagnosis. You could have in the 50s somebody diagnosed with, MS or Parkinson's, where you think there's a little bit of an increased risk.
But isn't it true, okay, you put, say, some sort of account, a lot of money in that trust, and you have a trustee. That trustee can go in and get the money for you if you need it, a certain amount. Is that true?
You want to answer that question?
So kind of the background overarching rule of asset protection is you're either going to need to give up control of the assets or access to the assets, and preferably both to really make it ironclad. So in Missouri, technically, you can be your own trustee of a self-settled asset protection trust, but we still don't recommend that. We don't recommend Medicaid seeing this copy of the trust, which we will willfully provide them if they ask for it. We're not hiding anything in these trusts. But I don't want them to see, you're the trustee, so exercise your authority as trustee to get access to this money. If we did make them the trustee, we would remove their access, meaning that the trustee then does not have the authority to make a distribution to that person directly. Usually it's the children that are the principal beneficiaries of these irrevocable trusts. Yeah,
this is an imperfect comparison, but some of you will have familiarity with a donor advised fund. Have you heard of that?
No.
A donor advised fund is something where you can give money away. Let's assume that you don't know specifically who you want to give it to, but it's getting near the end of the year and you want to be able to take a tax deduction. So there are a number of accounts or companies that offer this, and you technically transfer the money to that organization. They technically own it at that point, or at least they're custodians over it. But you, in effect, direct them as to where they're to put that money. So you can't use the money yourself at that point, but you can direct its use to others.
So when you say an organization, what does that look like? What are we talking about? What type of organization?
Well, like brokerage firms and stockbrokers and others, financial planning firms, et cetera.
Okay.
But that's a rough analogy. But the analogy is only that when you create this, remember, you should be suspicious of anybody who tells you that you can have your cake and eat it. If somebody says, oh, you can take $500,000, transfer it to a trust over which you have complete control and you can give the money back to yourself when you want, and at the same time be able to say to the federal government, oops, I'm broke. I don't have this $500,000 anymore. Give me, $1 million in benefits for all it could add up to. And then you decide to take your money back when you want it, the $500,000. You should be suspicious of any lawyer who paints that picture for you. But it is true that you can transfer the money. You get to control who it goes to. You can give it to anybody in the world. I mean, you have that right, but you're not supposed to use it yourself. Now, if it's a house, we need to talk about this. One of the most popular assets to transfer to a trust, the one that you arguably don't even notice because you continue using the house as you otherwise did. The fact that it's not on a deed anymore that has your name, instead it has your trust name, that doesn't affect any way in which you live your life. So houses are a very popular way to transfer an asset to a trust.
Absolutely. Not only the fact that it's almost unnoticeable once you've planned for the protection of this house, but most of the time it's one of the largest assets in the estate. And so it is one of the assets that people, want to protect, not only because it's easier, it's easy to put it in there and not really notice, but also it's not a liquid asset, so it's not affecting your day-to-day spending allotment. Like if I put all my cash in the account, the trust, you notice that. I have nothing to spend now.
Yeah, and some people, you should mention this too, some people are thinking, oh, well, what if I want to sell the house? Or what if my wife and I are going to sell this house and buy a condo in Florida? Can they still do that after the asset's been transferred?
They can. So normally the trustee is going to be someone friendly that they can say, and the trustee is going to, part of their job is to protect these assets and for the fiduciaries. Normally, when we set this trust up, one of the income beneficiaries is normally the grantor, so that the trustee can realistically say we're acting for the income beneficiary at least's best interest. So if the income beneficiary comes and says, I'd like to sell this house, it's too much for us, it doesn't make financial sense to keep it, and downsize to a condo in Florida or something like that, the trustee can say, absolutely, we'll sell the house, pool the money in the trust, and use that money to buy you a new condo, still in the name of the trust.
Yeah, so the short answer is, you can generally, if you want to sell your house and buy another house, it's generally not a problem. But you raised a good point. You can keep for your personal benefit the income. You can have the income directed back to you. So people say, well, what is income? It's really like interest. It's dividends. What would be another example? Generally, that's going to be the form that income is going to come in. So it means that it's not the asset itself. Say that you transferred $500,000 in cash, and that $500,000 were invested in stocks or invested in bonds. Those stocks and bonds are probably going to pay out, generate some sort of interest or dividend income, and that you can have paid back to you. So you are entitled to keep getting the income from those assets.
Okay. Now, what if you wanted to dissolve this entire trust? Is it still possible to do that, and is that ever done?
So it is done, and it is possible. So in Missouri, we use the Uniform Trust Code, and as a provision of this Uniform Trust Code, there are options to terminate the trust. Now, normally that's through a non-judicial settlement agreement, and I'm popping the Google search terms out here left and right. But it is basically if the grantor of the trust and all of the beneficiaries agree, they can modify that trust as long as it's not against one of the material purposes of the trust. So if they want to terminate and distribute the money out to the beneficiaries, they can do that.
Okay.
Technically, the assets should never come back to the grantor because they've given up their rights to access that principal. So they can dissolve the trust, but the money's not necessarily coming back to the grantor.
So what would be the point then?
Exactly.
Okay.
Yeah, I mean, there are people who figure, oh, well, I'll dissolve it and it'll go to my daughter and my daughter will give it to me. But, we tell clients that you really shouldn't go into this transaction unless you believe in it. And if you're doing it and you think there's a good chance or any significant chance that you're going to want to reach in and get that money, it really is, it's not appropriate to in the trust and then have the money given back to you by the beneficiaries. And it's a technical thing, but I would just say that whenever you're planning on doing this, you should be committed to the plan. And there's no reason to dissolve the trust. I just can't imagine that circumstance.
Mm-hmm. Yeah, the only time I've really ever seen these trusts terminated, it's usually after the death of the grantor when it becomes uneconomic for the, we've put $500,000 in this trust. Now it's divided 5 ways. It's not worth the administrative costs for a $100,000 trust for each kid.
That makes sense.
So the Medicaid recipient can only have what, $5,000?
In Missouri, yeah.
Okay. So say the spouse needs money, the community spouse.
So if there's a spouse, we've got completely different set of rules. So they're tied to each other, but when there's a single applicant, there's no one at home to not be what's called spousally impoverished. So basically what the states say, in the state of Missouri in particular, is that if there is a spouse going into a nursing home and there's a healthy spouse at home, the institutionalized spouse gets to keep $5,000, but the stay-at-home spouse gets to keep a little over $130,000, plus the house as long as they're living in it, a car, a few life insurance policies, but the cash surrender value is limited at $1,500 a piece, $1,500 total. For life insurance policies, some business assets as long as they're producing income, but it's limited to a $6,000 cap on those, and the income's got to be a certain percentage of the value. So, long story short, if the spouses stay at home, they get to keep way more than $5,000. They get to keep $130,000 plus some assets.
And it's really it's very cool because one thing we've not talked about is the rules about income. So sometimes people are more concerned about how much income is going to be generating and what's going to happen to that. Am I going to have to give it to the nursing home or to the federal government if Medicaid is paying for my long-term stay? And the good news is what really counts when it comes to income, unlike assets, is with income, it's the name on the check. So any income that is intended, whether it's retirement income, it could be a traditional pension that goes to we're using the phrases community spouse. These are terms you should probably get to know. Community spouse means the person who's not in the nursing home. And then institutional spouse, you're going to hear this phrase, institutional spouse is the person who's going to the nursing home. So the institutional spouse, we want their income to be, the name on the checks that come to them to be really as little as possible, quite frankly. And there are ways you can have some of that income pushed over to the community spouse. And remember, the whole idea is that, or an important component of this entire scheme or government plan, I should say, hinges upon assuring that the community spouse is not impoverished. So you have this Spousal Impoverishment Law that was passed in, I think, the 90s, in which they realized what they had done when they created these standards without regard to a stay-at-home spouse is that in order for the one who's going into the nursing home to get any coverage, that person literally was dirt broke and they were applying for welfare. And because everything was considered for purposes of that one person qualifying. So they realized that was an awful result. There was a big outcry about it. Congress passes, there are new laws that are passed, and in the early 90s there was this Spousal Impoverishment Law in which the goal was to say, look, any assets you own, we're going to count together. So the asset rule and the income rules are different. The asset rule says it doesn't matter whose name is on the property, it's going to be considered. So you can't simply take a piece of land, farmland, worth $100,000, $200,000 and just put it in the name of your spouse and be okay. All they care about for property, any property you own, stocks, bonds, anything, is that if either spouse owns it, both of them own it. Okay, so you got to keep that rule in mind. That's the rule for assets. But there's an entirely different rule for income because of this spousal impoverishment thing. So they're saying, look, when it comes to income, if the person who's staying at home, who's not going into the nursing home, if they have checks coming in from their work, from any assets that are in their names alone, then yeah, that's going to be their money. We're not going to consider it at all for paying the cost of this long-term care. So one complication in developing these rules, one reason that people hire lawyers who do this and only this, another caveat here that we mentioned before is it doesn't have to be TuckerAllen. Obviously, I believe mostly in TuckerAllen, but I think you can see from just what portions of this conversation you've heard and the things you know that this is a very specialized area. It's like tax law, so you don't want a lawyer who does this occasionally. And even as a estate planning lawyer, you've got to ask them how much Medicaid qualification, Medicaid planning, long-term care planning, how much of that do you do? And if they don't do a lot of it, you should steer clear. It's just too complicated. There are too many rules. It's like asking somebody to handle a complicated or just a tax planning issue. And maybe they're a business lawyer. And it's not enough to be a business lawyer and be capable of being a tax lawyer. Tax law is incredibly complicated, and so you're not just a business lawyer who does some tax law. If you dabble in tax law, you should probably do only tax law, and I think most lawyers know that. And the same thing with this is if you want to do estate planning, fine. But you better do a whole lot of this. At least 50% of your practice should probably be in this area.
Now, this irrevocable trust, if you have two spouses, say a husband and wife, is it created for both of them? And I'm talking about in terms of planning for Medicaid, or is it just...
It depends. I've seen we can do joint Medicaid asset protection trusts. Normally, we kind of split them up, especially for the fact that there's a level of planning that we can do because the qualifications are different. We plan differently for one person going in, two people going in. If we have kind of an idea of it, we've got a diagnosis here. Grandpa, dad is going in first and mom's pretty healthy. We think she's got 5-10 more years at home. We just plan that differently because she can keep a lot more at home, and it gives us opportunities to plan once we've gotten one qualified. So we do separate trusts quite a bit. We can do joint, but just because of the nature of the planning.
I would think that would get very complicated.
It does. It does.
So give us an example then of some of the things you might do. If somebody comes in and they have some assets, well, let's start with, should we start with the crisis scenario or a planning scenario?
Let's start planning and then go to crisis.
Okay.
Because that's when it gets...
So I'm going to throw just some very basic facts here, literally off the top of my head. We probably should have worked out maybe a sample. But we want to keep this real simple for learning.
It's a pop law quiz.
Yeah. This is a law school exam.
Uh-oh.
So incidentally, my daughter, I was trying to get her to do something to visit this afternoon, and she said, "Dad, I'm studying for the bar," and she is. She just graduated from law school weekend before last.
Oh, that's awesome.
Yeah, from University of Chicago. I'm very proud of that, and so she's studying for the bar.
Well, that's a good excuse then.
Yeah.
I don't envy her.
Anyway, so let me get us back on track. So we'll assume. Say $500,000 in assets, and let's assume that they each have, maybe the wife has $2,000 a month in income, checks that are coming in her name, and let's assume, say, $4,000. I'm trying to come up with numbers that are going to be easy to work with that won't require us to pull out a calculator. Just generally, the whole idea is not that you get to the penny on any of these calculations, but just to make a point. So they walk in, there's not a crisis now. So we'll assume that, they're older, maybe they're 70, 75 years old, both have various health issues. Neither is in perfect health, but they don't see a train coming down the track. So they want still to do some sort of planning for the possibility that one of them, let's assume they will have one person that is more likely than the other.
Okay.
So kind of play with that scenario and tell me what you're talking about.
So the first step, whether it be actually crisis or regular planning, is to figure out, okay, we've got $500,000 in assets, we've got $7,000 a month in income. We're going to need $10 a month in income at least, probably, 10 to 15. but we've got $500,000 in assets. How do we characterize those assets? So when you look at an inventory of assets, a list of assets in a Medicaid planning situation, you've got to think, are they countable for Medicaid purposes or non-countable for Medicaid purposes? And so the non-countable assets are going to be things like the house, one automobile, the life insurance, like I said, personal belongings.
You might wipe $200,000 or $300,000 out of that $500,000 just by setting aside the house.
Yes, exactly. Yep.
So now somebody's doubtlessly saying, well, wait, if I can do that, why are you telling me to put a house in a trust? So we need to hit on that.
Sure. So when a surviving spouse lives in the house, then it's exempt, and they can't attach a lien to it. There's someone still living in there. They're not going to impoverish this spouse that's staying at home. But what's to say that, okay, we think husband's going in first. Always pick on the males.
That's what the odds are.
Husband goes in. Well, okay, wife's great now. Then he stays in 2-3 years, and now she's got to go into a nursing home. Well, now the house isn't protected anymore because there's nobody living in it.
So it wouldn't go to their children.
Well, but
people need to know that when we use the word exempt, when Medicaid use the word exempt, it's not what you think. So we need to make clear that exempt does not mean that asset is not eventually sold.
It just means that it's not countable for qualification purposes.
For getting Medicaid in the meantime.
Yeah.
But it does not mean that house will not someday have to be sold to repay the government for the amount of money that they pay. It'll just happen in your estate.
Correct. Yeah, they'll do what's called a state recovery, which means during your life, as soon as if they pay for, and they use a timeline, it's 60 or 90 days, they'll wait until they put this lien on the house. But they will file a security interest, just like a mortgage, against your house. And so basically the state will be a first or second mortgagee, likely at that point in life first, on your house.
Yeah.
So that's why you want to put it into this trust.
Correct.
So Medicaid can't come back.
Yep. Once it's out of the applicant's name and it's been 5 years, then that house can't be attached for Medicaid purposes.
So in this example, we'll say $200,000 of it is the house. So would you at this point suggest that a house be considered for a trust, or would you go ahead and rely on the exemption for the time being?
So again, earlier the better on planning. At this point, we know more with 80% certainty that at least one of them is going to be needing care. I at that point would recommend this is a 75-year-old couple. I would at that point recommend that they might as well plan now for the house. If we need to do some penalty period calculations when the second goes in, we can do that. But it's much better to plan early than to wait until one's in and then roll the dice on whether there's 5 years between those two entries.
Yeah, so the good news is you get to start the clock on this house. And you may not get to 60 months or 5 years before one of the couple needs some sort of long-term care. But every month that goes by is an advantage. So it can be 3 years that go by, but there's a good chance that they may make it to 80 plus. Matter of fact, statistics are they'd probably make it 5 years before either of them needed to have long-term care. And so the house would be a great candidate to put in the trust. And some clients would say, well, fine, I'm just going to do that, and then I'll do my other estate planning with the remaining $300,000. Is that?
Yeah. Oh, yeah. Like I said, normally that house is the largest single asset for sure. And it's one of the easiest plannable assets because normally at that stage in life it's paid off, so we can transfer it freely without having to worry about the banks coming after us and saying, well, hold on, you changed title to an irrevocable trust. We're going to accelerate that mortgage and make it due now. Normally at that stage of life, we don't have to worry about that. Now, as far as the other assets, I said the house is the most plannable asset. If the other $300,000 of this theoretical estate has a lot of IRAs, qualified retirement accounts, those are trickier to plan with because you can't just move those out of your personal name. Qualified accounts have to stay by IRS rules in the name of an individual. So what we'd have to do with those is you end up having to cash them out, at least partially, pay taxes, and then plan. So that is more of a spread out plan. So we're not bumping you up a few tax brackets in 1 year. So when you talk about retirement accounts, which again, house and retirement is usually two of the larger pools of money or value, the retirement plans are a little bit harder to plan with.
Yeah, so then you could pour more money, some of that cash, let's assume it's not tax deferred like IRAs or 401ks. Those we can still work with, but for the reasons you said, we proceed cautiously. We don't want to trigger tax to be due on those by transferring them into a trust without thinking it through. So sometimes we won't transfer any of those particular assets, and we will instead let them go into the trust when you pass away. But for other assets, it might be that you want to take that money and dump it into the house.
Right. So that is part of the converting countable assets to non-countable assets. So again, you've got a house, you've got a car, those two assets are exempt. House needs a new roof. That's part of the spend down. So we know how much we need to get down to and how much we need to get rid of to qualify. Once we have that number, we can start putting countable assets into non-countable, so converting them over. Like I said, put a new roof on the house, remodel the kitchens and bathrooms. There's an easy $50,000 to $100,000
Right.
we've spent. Get a nice brand new car, that's exempt. There's another $40,000.
Get a Maserati.
Yeah, get a Maserati, right? Prepay your funerals, so $15,000 a piece on prepaid funerals, and you can do that in a number of ways. You can do it by just simply going to the funeral home and giving them money and paying for it and getting a contract back. You can put them in an irrevocable funeral trust that's set up specifically for those assets. You can get prepaid not life insurance, but prepaid funeral policies that acts kind of like a life insurance policy that actually grows once you've set it up. And then you can simply just earmark it in an account that you specifically call the funeral fund or something like that.
And there's no actual limit on a car, is there?
No, the house, there's a limit, but it's pretty high.
So on the car, there's always a reasonableness. So the reason that you end up getting absolute limits developed, where they end up with a dollar amount as a ceiling, is because it's driven by somebody out there who said, oh, I don't see a limit on this, so I'm going to buy a Maserati or a Ferrari.
Right.
So, but this is true that you can go fairly high and it still be reasonable. It wouldn't have to be a $20,000 car. Now, if this were way out of line with anything you'd ever done in your life, it might be questioned because there's room for interpretation. That's the problem when there's
Could raise some red flags.
Yeah, that's the problem when there's not a bright line.
This 92-year-old is now driving around a bright yellow candy apple red Maserati. Seems legit.
But you can. I want people to know that you can spend. We've had clients that have spent $30,000, $40,000. But when you start getting much higher, unless you've had a history, unless that's perfectly normal for your lifestyle, it would be questioned and challenged, and maybe successfully challenged. So you want to be careful how high you push it. But the point is, the alternative. Remember, you may say, well, gee, I don't think that's the best use of my money. Remember, otherwise the money's going to be gone anyway. So whenever particularly for people who are doing crisis planning, meaning you've gotten a diagnosis of some sort, so for those people this is easy because there's go to the federal government, lose everything is option A. Option B is spend it on any of these other items. And as long as those other items have some value to you, then that plan makes sense. And this is not illegal. It's not inappropriate. That's the reason that you do have guidance on these assets. But investing in the house is one of those. One thing I want to follow up on, some people are thinking that, well, wait, so if you have this rule on houses, so why would you want to put it in the trust? You're still going to lose it, aren't you? And I want to be sure they get it, that if you keep the house out, it's true. There's a good chance you'll keep the house till your spouse dies or till you die. The latter of the two, we'll say. There is a good chance of that. But it's much better when you put it in the trust because the trust not only allows you to qualify, but also allows you to keep it permanently. I don't think everybody got that. When you put the house in the trust, you get it permanently. You don't have to turn over the house to pay for
You're fully protected.
Right.
Then.
Yeah, forever.
Yeah, and then your heirs will inherit that home.
Exactly. That's the point.
Yeah, so if you think of it this way, you don't personally own the house anymore. This irrevocable trust, which is a separate entity, owns the house now. So if the state tries to say, well, we're going to file a lien against this house, it would be like me saying, well, I was in the nursing home, but my neighbor I never really liked, so put a lien on his house. It just doesn't work that way. The neighbor has nothing to do with it. The trust has nothing to do with it. So they can't put a lien on that property that's not owned by you.
So you can put bank accounts into this type of trust. Am I right?
You can, absolutely.
Okay.
Stocks?
Yep.
Yeah, any
Just
securities.
not IRAs. You have to cash those in?
You would probably owe taxes on it if you transfer those in.
Yeah. Yeah, the tax benefits from qualified retirement accounts like IRAs, 401ks, Roths aren't that big of a deal because taxes have already been paid on those. But the main thing is for the tax growth to be the growth inside those IRAs, those qualified accounts, to be tax free, they have to be owned by the individual that hasn't paid taxes on them yet.
Okay.
Yeah. And let's talk a little more about, at the risk of totally confusing everyone, but I want to continue a little more down this road. So this couple has come in. They're not in a crisis situation, but they're older. So they have this $500,000. We said $200 is the house. Let's go ahead and do what would be called a division of assets so they understand how that works, how you determine the community spouse gets to keep certain assets. So that, remember, we didn't mention that. If you're married, in addition to all these things we've mentioned, you also get a set-aside money for the community spouse. And that can be a substantial part of what your assets are. So let's go down that road then.
Yeah, so normally when we're talking about the standards for a community spouse, typically I see these normally are a crisis situation. So if we're pre-planning, we, to use these numbers, we kind of in our head say, we know husband's going in first. He's years beyond in health what mom is. So at that point, we can plan as far as him going in first. So we say, all right, we've got the house. We're going to transfer that into your irrevocable trust. We've got $300,000. Let's just assume for ease of illustration that they're not IRAs, 401ks. There's $300,000 in cash. So what we do...
Or in stocks or securities.
Yeah, right. So at that point, we say, okay, we'll put the house in $200,000. If we put in $170,000, you're at the community spouse resource allowance at that point. So then we can say, all right, we know that you'll be able to keep at most $130,000. So we'll keep that out. You can live on that until dad needs to go in. 4 years go down the line, dad's now going to the nursing home, but we've got to wait 5. So at that point we say, okay, we had the $130,000. The snapshot date is now when dad has been in a nursing home for 30 days or more. That's when the division of assets occurs, is the snapshot date. So there's another Google term for you. So that snapshot date, then we know exactly, we've got a year left to pay. It's $120,000 for that year. We've got $130,000 outside the trust. But the snapshot date will say, at that date, you had $130,000. We're dividing it in half. That's the community spouse resource allowance now. So you get to keep $65,000. You got to use the rest to pay for dad. Once that's gone,
to pay the nursing home.
To pay the nursing home for dad.
Okay.
Once that $65,000's gone, you will qualify.
So it's not after the division that there's $130,000 that could be set aside.
No, so it's
50%.
Yeah, it's whatever's higher, the maximum allowance, or the divide in half. Now there's a minimum too. So if it falls down, if it's $5,000, they're going to let you keep the whole thing, depending on. So there's a range, and I can't remember the low number. The high number is the one we usually deal with. But
so now let's talk about, though, some of the planning you can do around the subject of income. We can use this same couple as an example. And also I want people to notice that it is possible to increase that $130,000. You can actually sometimes move more money over to the spouse that's going to be in the community based on, remember that statute we mentioned. The law is concerned that the community spouse, the at-home spouse, does not starve. that they're not punished in order to get their wife or husband medical care or to get their wife or husband, the sort of long-term care they need. So do you want to pick up with that?
Yeah, so part of the counting, recategorizing countable to non-countable is potentially purchasing assets and converting straight assets to a stream of income. And usually that's an annuity, or you can purchase, stocks and carefully valued stocks so that they're not countable. But most of the time I see Medicaid compliant annuities in this space. And those are converting countable assets to a stream of income. But at the end of the annuity, that money that you use to buy it has to be paid over to the state, whatever's left. So that's why they're Medicaid compliant annuities. But it does help fill gaps in the look back period. And like you said, the community spouse can keep as much income as she's got the name on the check for. So we try and do that and spend, $50,000 to, get 5 years of income for her is.
Yeah. So remember this rule we mentioned, that the name on the check is what governs income. And for assets, it's if either party owns them, it's going to be counted as the asset of everybody, right?
So you only want one of the spouse's names.
So yeah, you want the spouse who's not in the nursing home. So this is an oversimplification, but this is an example. Let's assume that $200,000 you had kind of run out of ideas, and we'll jump to a crisis scenario. And so, what can you do? In this case, you could take an asset that is in both parties' name. Actually, it could be owned entirely by the person who's going into the nursing home. We'll assume it's the husband, okay? So we'll assume the husband has this asset that was in his name. Now, remember, it's regarded as the asset of both of them, right? So it's an asset and it's worth $200,000. He can transfer that asset to his wife. Now, this is something we haven't talked about. When you transfer assets between spouses, it doesn't violate the rule about not being able to transfer assets to third parties for less than fair market value. That's not the rule when it's between spouses. You can go back and forth in assets between spouses, and it doesn't matter because it kind of makes sense because they're going to still count them for purposes of assets. So what you do is you transfer an asset from this husband who's going into the nursing home to his wife, $200,000. The wife takes it and buys an annuity, and the annuity is payable to her. So now think about what's happened there. You've taken one set of rules, the rules governing property, and those rules say it doesn't matter whose name it's in. So you didn't violate that rule. You transferred the asset from the husband to the wife. Now you're wanting to engage another set of rules that says what really matters is the name on the check. So with this asset just acquired by the wife, she buys an annuity and has to comply incidentally. It can't be any annuity. We won't get into these details. But as Jim just mentioned, it does have to be a Medicaid compliant annuity. But anyway, put that aside. So he takes this $200,000 sitting in his name, and he buys an annuity with it to be payable to him. Guess whose name is on that check? His name. So what you've done is there's a sort of magic by which this asset has disappeared as a community asset, and what's left is money that's coming in with his name on the check. So this is just one example among others that you can do in planning. And just by bothering to go to lawyers that focus in this area, you can end up qualifying to allow others to keep assets, whether it's your spouse, whether it's your loved ones after you. And so why go ahead and just throw it all on the table and say, take it and give me a nursing home bed.
Yeah.
And that's plan B, is that you just say, here, go. Or the same thing is to say, okay, so I'm supposed to be down to $5,000, fine. So you make application, you go into a nursing home, and you just start writing checks every month. Whether it's 10, and again, we're using 15,000 because I think that'll be the number if we're talking 3 years from now.
Yeah.
So So, just writing a check. Oh, it's all gone. Now I qualify for Medicaid. Thank God for Medicaid. But there's a better way is the point we're making.
Well, Jim, what happens, though, in this situation, we've been talking about the husband going in first. So we've been planning for the husband. What if it turns out we were wrong and the wife goes in and we haven't planned for her?
That's
still crisis mode, right?
Then we're kind of in crisis mode because we've got previously healthy mom that we had, kind of put money on was going to stay at home for 5 to 10 more years. And we've got sick dad that can't possibly stay at home but for mom. And so now we're talking, now we are in crisis mode. And the asset limit jumps up to, wait for it, $10,000 if there's two spouses at the same time applying. It's $5,000 each. But then we don't have any community spousal resource allowance. The name on the check rule is not going to really apply because they're both institutionalized now. And so, we really are talking about it's a crisis.
But they're still, remember, they're still in better shape than if they had never planned.
Right.
They're in far better shape than if they'd never planned.
Yeah. And so depending on how many months it's been since we started planning for dad, between mom getting sick and that planning date, you're still talking about basically $10,000 a month or whatever the cost is, $15,000 a month that you've been kind of pocketing as the time went by between the plan and mom getting sick. So at that point, once we get into crisis mode, it's kind of a what situations are we in? So the house, for example, it's technically exempt, but it is going to be subject to a state recovery.
Right.
So thanks for the exemption, state.
But now this wouldn't have been a problem, though, if, I don't know, in your scenario, if you assumed that we had done full planning with the other assumption, because this would go away as a problem if in that initial case when we did the planning, thinking the other spouse would be the only one that needed long-term care, is that we move the house into a trust so that the house is protected.
Right.
So when this new scenario comes up, your house is covered either way.
Mm-hmm. And so let's assume, I guess, as far as the planning concerned, so they came in, we put the house in the trust, we kept out $130,000 thinking that's kind of, the most we'll be able to keep, and we put $170 in the trust as well with the house. So now you've got $130,000 to kind of work with. You're talking $10,000, $15,000 for care. So we're going to last a little bit over a year, and then we've got to kind of get to the point where, oh no, we're out of money except for the money that's in the trust. How do we kind of get that back? And you can do things in the meantime with crisis planning. We do personal care contracts with the kids that say, they're helping out with care and that they're getting paid for doing it. It's not just out of the goodness of their own heart like they had been.
Yeah, and that's an important point you're making. I want people to appreciate that this is one of the techniques. Is how much can you pay out legitimately?
So it's got to be a kind of a fair market rate, and that's kind of for in-home health care services. We usually say like 20 or 25 tops. It depends on the area, obviously, but around here in the St. Louis area, we say 20 to $25 an hour. And really the number of hours kind of depends on the relationship, how many kids are helping, and whether or not they're in a nursing home already. So if they're in a nursing home already, obviously we can't be saying they're providing 40 hours a week of care.
For the one that's in the home.
Right.
But if you can delay admitting them, and that's the scenario we're assuming is the other spouse develops a problem. And if you can, by using loved ones like grandchildren.
Yeah, normally it's children, even adult children. But yeah, grandchildren. If you've got family members that are helping, and when we do these care contracts, we give them a log to keep. So keep track of your mileage, and you get reimbursed for that on top of the compensation. And then just keep track of it took mom to the grocery store today. That's 2 or 3 hours. And so, you want to keep track of that, but it's got to be a reasonable amount. We can't say, 100 hours a week at $1,000 an hour or anything like that.
Yeah, and that's the thing to emphasize, too. This case went all the way to the Missouri Supreme Court on an issue of whether or not you can effectively transfer a lot of money to family members by paying them to do, through a personal care contract, personal care services. And where the Supreme Court landed is that it's got to be real. It's got to be documented. There are like 5 or 6 criteria, and you've named most of them.
Yeah, and I think the main criteria that the state has in their mind that justifies them even allowing this still is that for every dollar they're paying for these home health care, the caretaker, children and grandchildren and family members, is every dollar you're paying them is a dollar the state's not going to have to pay out because you are delaying that entry into a nursing home.
Now, is it possible to plan for Medicaid for both spouses? Say, both spouses are in poor health and it's anybody's guess who is going to go in first. So is it possible, and is it done very often?
It's possible, and it's done fairly frequently. I mean, if both spouses are roughly the same age with roughly the same health, I mean, we can't just say, okay, flip a coin, who are we planning for first? And so in those scenarios, we plan for both. If we're planning for both, there's likely going to be a significant chunk of money that we just have to leave out of the plan. And you'll lose
so
the
they
house.
can live, so that they can live.
Exactly,
right.
exactly.
But keep in mind, some of the biggest assets, we know it doesn't matter, like the house. We know at the house we're going to move it into a trust.
Well, yeah, that's a given.
And so that takes up maybe half of the marital estate or the estate of the couple. So the thing to keep in mind, though, is whenever you're considering who's going to go in first, you still have the options of transferring money in different ways. We talked about a personal care contract, and that's something that you can consider really at any time. I mean, it's got to be legitimate, though. So let me emphasize this. I don't want people to walk away thinking, oh, we take a piece of paper and we call it a contract and we pay back for. One of the rules that in this case, I think it's the Supreme Court that ruled that you couldn't go back more than like 30 days or something.
For the care contract?
Yeah. It's got to be forward-looking. You can't do the stuff where clearly it's manipulative. And people, what brought this case to the Court of Appeals was that people were saying, oh, gosh, we have this crisis situation. Hasn't our son Tom been helping out for the past 5 years? Let's pay him $100,000 for the help he's given over the last 5 years. Those retrospective contracts are clearly not acceptable in Missouri. And so you can go back like 30 days at most, but the best idea is don't go backward at all. Go forward. Mm-hmm. And as you said, try to keep it reasonable, document. And then, those who withhold, if you think about it, if you're in a situation where you can do that for like 3 years in advance, that's not unusual. Somebody who's having problems, but think how much money you can transfer during that period of time at $25 an hour. Yeah. So that's not a small thing where you have some opportunity to do transfers, but it's not something you do retrospectively.
No. And you can't necessarily, as far as the retrospective planning or retroactive planning, this money is taxable income technically to the children and the caretakers that are providing care and receiving payment. It's taxable income they're going to have to claim on their personal taxes. Normally, it's not enough to really mess with anyone's taxable rates or anything like that. But technically, because it's not a gift, it is payment for services rendered. Technically, they are 1099 employees of yours that you should pay.
Do a 1099. Yeah. Do the things that you would do with an arm's length transaction.
Right.
Talk a little bit about another common technique in this crisis scenario is if somebody has a pot of, say, $200,000, and we sometimes, as lawyers, call it a half loaf. And this is difficult to explain. You almost need a pencil and paper to follow what we're telling you, how this math works. Because I remember when this plan was first explained to me years ago by another lawyer, when he said it to me, I didn't see how you end up being ahead 50% or so of the amount you start with. So you've got to think about this carefully. Do you want to undertake talking about that?
So the half loaf basically is, so we mentioned the snapshot date. And so you take the amount of assets that you have at that snapshot date, and you divide it up 50-50. And then you can actually apply for Medicaid and get the penalty, and then use the half that you had given away and gifted away, basically get it back and pay the penalty period down, and then you qualify when that penalty period's over. And so it only obviously works if we've got a stay-at-home spouse. But it's a way to kind of, like you said, it's play with the numbers. So, okay, you're going to give me a penalty period. That penalty period's less than 60 months, so I'm just going to take that. That's how long I'm going to pay. Since we've divided all of my assets up, we've calculated the spend down period. We're gonna use it. We're gonna use your numbers, and we're gonna pay for 42 months or whatever the number comes out to be.
Yeah. And here's another way to think about it. In its most simple terms, even without the refinements you mentioned, there are ways you can refine it it can be much more effective. So you have $50,000. Your penalty is in the state of Missouri is going to be around 5,000. Is it 5,500?
It's like 65 now.
Uh-oh.
I know the math.
So look at this inflation, because it was 5,500 just 2 years ago.
Well, and it's supposed to be based. That's the penalty divisor, and it's supposed to be based on. In Illinois, it's just the price of care. It's the monthly price that you're actually incurring, and they base the penalty on that, which makes too much sense almost. Missouri takes the average for the entire state, the average cost. So luckily, or I guess unluckily maybe, for St. Louis people and people that live in the higher priced areas, it's based and drugged down by rural areas that have a low cost of care. So technically, if you give away $50,000, for example, and they're dividing it by 6,400 or 6,500, and the nursing home's actually 10,000, you've got a longer penalty period than it's actually costing you.
Yeah, and that's part of the point is that the way the math works, you end up getting credit for a substantial part of the transfer. So there are, whenever we talk about these, the point is less to teach you about complicated strategies. You shouldn't have to know these things. It's to communicate to you generally the fact that there are planning opportunities. So we went through an example where there's some time to plan. And then we talked about some examples where there would be crisis planning. One thing that we may not have dealt with as well before we wrap up is talking a little bit about how income works or doesn't work. So let's go back to this example, and let's talk about it if there were planning in advance or if there were a crisis. Just looking at the income piece so that people understand, well, gee, I have too much income to qualify for Medicaid. I'm not impoverished. I have middle-class income, you may be thinking. But there are still things you can do where you may qualify, and it's really a matter of the cost of the nursing home. That's really more important in Missouri versus other states where, if you're not at the poverty line, essentially, in income, the discussion's over. You can't qualify. You can't even apply for Medicaid. And whereas in Missouri, the question is not whether you're at the poverty line of income. That's irrelevant in Missouri. What's relevant in Missouri, though, is the relationship between the income that's going to be assigned to you, which may not be your actual income, and what the cost of the nursing home is. And I'll toss it to you.
Yeah, and so obviously that is going to depend. So if there's a community spouse, we want to get, like we had mentioned before, all of as much income as we can that's reasonably possible assigned to that stay-at-home spouse. Now, if we're in a dual situation, they're going to say, okay, we can apply. You're not disqualified because of your higher income than cost of the nursing home. There's just nothing for us then to pay out. And so you may have a really high income, but you also may have healthcare costs that bring your income down. So let's say you've got $12,000 a month coming in income in retirement. The nursing home's $10,000. You apply, you spend all your assets down, but you still have this big level of income. The state's going to say, okay, yeah, that's great. You qualify. You're below the asset limit. We'll approve it. How much are we paying out now? And there's no shortfall, so there's nothing for the state to pay out. So you're not disqualified because of income, but there's no reason for you to apply.
Yeah,
Right,
you just don't. By their calculations, you don't need the Medicaid because it shows that they're going to assign income to you that's in excess of the cost of the nursing home. And that's where there's some opportunity for real planning. And we haven't talked about the fact that, there are a lot of costs, living expenses that can be assigned to the community spouse, the person that's staying at home. And it really works out where you're the person staying at home. And this is not uncommon. We're going to be a little sexist here. It's a huge statistic. The difference between men, the rate of decline, and women, I mean, it's shocking. You go into a nursing home and you look around and you look at men versus women.
Yeah.
I mean, I'm telling you, there's this difference of like 7 years really shows up in nursing home care between men and women. So it's not unusual. And historically, men were earning more than women. That's not true today, but historically, there were a lot of women who stayed at home. And they were homemakers. So for those people who now are in the baby boomers, and these are a lot of people who are going to nursing homes, it's a real opportunity when we'll say the guy who has a big check coming in, wife has no check coming in. So we want you to understand that's not an obstacle because there are things that you can do to have that money reassigned to her based on her needs on the income, even though the name on the check is his. And that's true. That's a general rule. But there's also a rule that assures that a spouse in this situation, a homemaker, is not going to be impoverished.
Are we talking about like a pension?
It could be a pension. It could be even investments that are in his name. But talk about how that works.
Yeah, so like we said, transferring assets, so income-generating assets we'll want to transfer between spouses. That way, the dividends and interests that are coming off of those investable assets, the name on the check is now stay-at-home spouse. As far as pensions and things like that, we could theoretically, those come to husband. Social Security, obviously, we're not getting reallocated, but we could use things like there's a living expense allotment that the
housing, cost of the house,
right. And so things like that. Let's say there's a $1,500 mortgage and surviving spouse only has $1,000 in Social Security coming to her and the investment income. Well, they're not going to throw her out of her house because of that. So the cost of the house can be pulled from husbands. Basically the resource, the living allowance is what they give her.
So you're not changing the name.
No, but they're not. Yeah, it really comes down to that spousal impoverishment. If husband's got all of the income, they can't just take it. They've got to allocate some back to the
So the way it works is in your example where maybe there was income of $10,000 a month, but it was almost all going to this husband who's retired, had a job, let's assume a traditional pension, and the nursing home cost, let's assume, is $8,000, or it could be $10,000. He doesn't benefit if he doesn't get some of that money saved. He doesn't want to end up using his whole check, and he wants Medicaid to pay as much as possible. So his goal is to push his income down, and there's a mechanism where the spouse needs it to have that money reassigned to her. So if she needs $5,000 a month, then all of a sudden he's going to go from 10 to 5, which means Medicaid now is paying $5,000 a month. So there are a variety of ways in which you can plan based on income, not just assets.
Right. And there's numbers that the state gives out as far as a minimum amount of income that they're going to give the surviving spouse, and if hers is lower, they'll reassign it. But again, and then buying income-producing assets is a way, but that's more of an asset planning tool than it's an asset reduction tool while also increasing income for that surviving spouse.
I just have to ask, how many semesters did you spend on all of this? This is so complicated.
Unfortunately, they don't teach stuff like this really in law school. They teach the bones and the tools that we use, the trusts, the wills, the powers of attorney, the contracts, but they don't actually tell us how to use them.
No, unless law school's changed, there is no course on Medicaid qualification. It's something
should be.
You just have to figure out. Unlike tax law, there's an abundance of courses in law school, so people who are going to be tax lawyers. But I think as our audience can see, this is very similar. It's a type of bureaucratic or administrative law that has its own sets of rules, and they are very complicated, and they vary from state to state. And so we'll wrap up, I think, We'll wrap up by my mentioning again the fact that you want to focus on lawyers who do this area as a large part of their practice. And a lot of estate planning lawyers don't touch this, and I understand that. They for the most part, they all try to serve rich clients, because that's where the tax law comes in and just a lot of meaty stuff as well as bigger fees. But so it's the dream of the vast majority of the community that does estate planning, quote unquote, is to serve wealthy clients. And so TuckerAllen's practice is more based on middle-class clients, and so this is a core component of the sort of planning that you do when you're in the middle class. Now, you have clients who come to the door and they have no interest in doing Medicaid planning, and that's fine. It's something that it's our duty to present, and some say, no, I'll assume the risk. So,
yep.
Yeah.
Yeah, so it's really, I mean, the crux of the planning is figure out how much income you're kind of going to have in retirement, and then look at the level of assets you have, and you can do that simple math problem of take the number of $10,000 to $15,000 a month, subtract your income, and that is how quickly your assets will deplete. And you'll have an exact number of if you sold everything that you have of all your worldly possessions and I guess joined the monastery nursing home, how much, how long you would be able to pay for it. And it surprised you how fast it goes. And I almost bet, vast majority of our viewers right now and listeners would last less than 60 months.
It's amazing.
Yeah.
And the shame is that it's one thing if you can't leave your loved ones a legacy, a financial legacy, because it just didn't work out that way. There was no way to do it. But it's another thing where through good stewardship, you could have,
right,
but you didn't for reasons that you just chose not to plan. So that's a good point to end on. So we covered a lot of material here. I know it's confusing. Good news is you can rewatch it and listen more closely. So we invite you to also look at the first one if you haven't already. We will in the future come back to Medicaid. It's such a meaty topic. But we covered a lot of territory. This has been a wonderful episode. Jim Gau of TuckerAllen, marvelous guest.
Thank you for being with us.
Thanks for having me again.
So till next time, another episode of ElderTalk. Take care.
You've been listening to ElderTalk with TuckerAllen, providing intelligent answers for those thinking about their future, with Attorney-CPA Joe Cordell. Sponsored by TuckerAllen, your estate and elder law advisors. For more information, visit TuckerAllen.com. Listen again next Saturday for another edition of ElderTalk with TuckerAllen. The choice of a lawyer is an important decision and should not be based solely on advertisements.